Righty, good morning everybody, and a very, very warm welcome to you to today's ThinkLegal webinar, Parental Responsibilities and Rights, Understanding the Essentials. I look forward to unpacking this very, very fundamental and foundational topic with you. For those of you who have attended quite a few of our webinars before, like me, you will obviously know that, when we talk about parental responsibilities and rights, it's something that is so fundamental and so back to basics, if I can use that term, that it almost becomes trite. And I'm hoping today to give you a bit of a different perspective and a bit of a different understanding on parental responsibilities and rights to better enable you to explain these concepts to your clients, as well as to better understand them yourself. Thank you so much for taking the time to attend today's webinar. I really do appreciate you taking time out of your day to be here with us. And I really hope that today's webinar will be of benefit to you. Just some housekeeping before we go into the webinar. You will note that we are using the Teams webinar platform, so you are unable to unmute yourself or switch your video on. There is nothing wrong with your computer. It is simply a safety measure that we have implemented. Nevertheless, we really do encourage participation in the session. You can do so by chatting in the chat bar. You'll also see that we have a Q&A button, which you should be able to find at the top of your screen or your browser, wherever you are viewing from, and you'll be able to type in some questions for question and answer. Right. Before we go into the presentation, a little bit of housekeeping. I would like to just remind you of next week's webinar, where we're going to be speaking about deceased estates and what to do when there is a obstructive or a malicious executor of the deceased estate, what to look out for, and how to protect the interests of the beneficiaries under the will or under the intestate estate, as it were. Then we will also be sending out a few save the dates. We are going to be doing a session early next month on the FDF, which was recently introduced in the Gauteng divisions. We're going to be looking at how to complete the FDF, what to look out for, what are the pitfalls, etc. And then finally, we have had enough interest in our poll that we sent out yesterday that we are going to be arranging and putting together a family practitioners breakfast on the 19th of May. Further information to follow, and please just for now save the date. For those of you who are not yet on our WhatsApp groups, Nadia is going to be sharing the WhatsApp group links if you would like to apply to join either our commercial group or our family law group. We are planning quite a bit of content on the commercial group in the foreseeable future, so please look out for that. Right, so let's talk about parental responsibilities and rights. One of the most foundational issues in the Children's Act, and very often one of the most misunderstood concepts in the Children's Act, in my humble opinion. The first portion of today's talk, which is incidentally not going to be a very, very long talk, depending on the participation that we get, we're looking at about an hour to an hour and a half for today's session. So let's start here. Can we define parental responsibilities and rights? Now, in terms of the Children's Act, ladies and gentlemen, we know that Section 18 says to us the parental responsibilities and rights which a person can have in respect of a child includes contact, care, guardianship, and maintenance. That tells us what the elements are, but it doesn't really tell us much about what parental responsibilities and rights in fact are. Is it possible to postulate a very simple one-liner kind of definition of parental responsibilities and rights. Now, folks, I have tried my best. I don't know if it's a perfect definition or not, but I think that it gets quite a bit of it. And I managed to distill it down to 2 short paragraphs. I couldn't get it any shorter than this without losing the essence of it. Parental responsibilities and rights is a group of responsibilities and rights that a person may have in whole or in part in respect of a minor child. The Children's Act defines the parental responsibilities and rights which a person may have regarding a minor child. These include contact, care, guardianship, and maintenance. I would encourage you to start from this position and to try and distill it down even further, because very often we are, as family practitioners, whether we are attorneys, mediators, social workers, psychologists, etc., faced with clients who don't understand the concept of parental responsibilities and rights, and we very often have to explain it to them in very, very simple terms. Going into a soliloquy on what is contact, what is care, what is guardianship, what is maintenance, very often leaves clients confused, and they then go back to the default of talking about custody and access as we had in the old days. Try to distill down the concept when you explain it to non-lawyers, if I can put it that way, into the basic constituent terms. And as I say, what I say parental responsibilities and rights is it is a group of responsibilities and rights that a party or a person may have in respect of a minor child that can be either in whole or in part. Very important, ladies and gentlemen, I didn't say a parent may have, because the Children's Act goes further than that. It's not just parents who have parental responsibilities and rights. Now, if we go further from understanding this very, very brief kind of definition of parental responsibilities and rights as a whole, and I'll just quickly go back to it for the benefit of those who are joining us now. I see a lot of people are entering the room now. Once we know as a holistic, broad term what is this beast that we call parental responsibilities and rights, we need to look at the constituent parts. And I've really racked my brain to see how to visually describe this idea of parental responsibilities and rights. And I've found a few things online. I looked on various resources. I even went so far as to go to ChatGPT and say, this is contact, this is care, this is guardianship, this is maintenance. What are parental responsibilities and rights? And describe it to me visually. The best one that I could come up with was simply explaining parental responsibilities and rights as a car. And the 4 constituent parts, contact, care, guardianship, and maintenance, being the 4 wheels of this car. There is no difference between parental responsibilities and rights and the concepts of care, contact, guardianship, and maintenance. And the reason why I like the analogy of likening parental responsibilities and rights to a car and each of the 4 portions of it to one of the wheels is that I can make the silly pun of saying, you know, if you neglect any one of these 4 issues, the wheels are going to come off, ha ha. But it really does go a long way to saying that the whole experience as a parent or a holder of parental responsibilities and rights to a child, in order for this to be balanced, you need to really focus on all 4 of the constituent parts: contact, care, guardianship, and maintenance. Anecdotally, I had a debate a few years back with a social worker who was having an argument with a magistrate in Krugersdorp, somewhere outlying. I can't remember exactly which court it was, but there was this argument with a magistrate who said, well, you can't do guardianship here, you can only do parental responsibilities and rights here. And I said, no, but guardianship forms part of parental responsibilities and rights. It's not something that is separate. Now, we know that the Children's Act until very recently limited guardianship issues to the High Court. But understand that it's not parental responsibilities and rights over here and then contact, care, guardianship, maintenance on the other side. These four factors all work together to cumulatively constitute parental responsibilities and rights. Now, that takes us to this section in the first paragraph, in whole or in part. Always bear in mind that parental responsibilities and rights as a package, if you have full parental responsibilities and rights, include contact, care, guardianship, and maintenance. However, if you only have partial, you can have only a right to contact but not have guardianship. You could even, under certain circumstances, under Section 21, for example, have a responsibility to maintain the child without having any of the other responsibilities and rights. So for the purposes of the rest of this discussion, understand that it is not something that is separate or different. These four concepts are the constituent parts of parental responsibilities and rights, and cumulatively they are the four wheels on which the car of responsibilities and rights functions, or the four legs of the table, or the four legs of the horse, or whatever the case may be. So now that we know what parental responsibilities and rights are, let's start looking at the constituent parts of parental responsibilities and rights and go into a little bit more depth into what each specific parental responsibility and right under the headings contact, care, guardianship, and maintenance consist of. So let's start with care. Ladies and gentlemen, the concept of care can be found in the definitions portion of the Children's Act under definitions and interpretation. And there is a beautiful point-wise, very broad definition of care, but it doesn't distill it down. I'm going to try and distill it down. We're going to try our best, but let's look at, firstly, right at the bottom of your screen, you'll see the dictionary definition. Now, we know in law to be very, very careful of dictionary definitions, but I think for present purposes, it helps us to understand it a bit better and to set the stage. Care is defined as the provision of what is necessary for health, welfare, maintenance, and protection of someone or something. That is our dictionary definition of the concept of care. Now, we know that the legal definition is a little bit broader. Now, let's see what the Children's Act says, and then we'll try and distill it down. The Children's Act says, within available means, providing the child with a suitable place to live, living conditions that are conducive to the child's health, well-being and development, and the necessary reasonable financial support. Safeguarding and promoting the well-being of the child, protecting the child from maltreatment, abuse, neglect, degradation, discrimination, exploitation, and any other physical, emotional, or moral harm or hazards. Respecting, protecting, promoting, and securing the fulfillment and guarding against any infringement of the child's rights as set out in the Bill of Rights. Guiding, directing, securing the child's education and upbringing, including religious and cultural education and upbringing, in a manner appropriate to the child's age, maturity, and stage of development. Guiding, advising, assisting the child in decisions to be taken by the child in a manner appropriate to the child's age, maturity, and stage of development. Guiding the behavior of the child in a humane manner, maintaining a sound relationship with the child, accommodating any special needs the child may have, and sub J, I really like this, generally ensuring that the best interests of the child is the paramount concern in all matters involving or affecting the child. Now, I don't know about you, ladies and gentlemen, but if I were to sit down with a client and read them this list and say, this is care, I would probably be faced with a blank stare of someone saying, you know, this is overwhelming. And one cannot blame them, specifically also because there is such an overlap. If we look at, for example, sub H, maintaining a sound relationship with a child, when we go into the concept of contact, there is an overlap. If we look at within available means, providing the child with the necessary financial support, we go into the realms of maintenance, etc., etc. Let's now try to distill it. I'm hoping that I can distill this down quite nicely into a single sentence. Now, before I go to the single sentence distilled Cliff Notes version, understand I don't base it on anything other than my own endeavors to make it shorter and more understandable. It's not legally recognized. If you want to really not fall foul of the law, always go look at the definition in the Children's Act. This is simply an aid to understanding, and you'll see I also put it very clearly in my PowerPoint slide, not legally accepted. See Children's Act for full definition. What I postulated is the following, folks. Care is the provision of a safe, supportive, and nurturing environment that promotes a child's well-being, protects them from harm, and ensures that their best interests are prioritized. Now that becomes something a bit more palatable and a bit more digestible for clients to say, you know, care is really protecting, safeguarding, and supporting and nurturing your child. Being a parent is all about care on a day-to-day basis, not to take away from the issues of guardianship, contact, etc., but care really sums up what it is to be a parent to a child on a day-to-day basis as far as they perceive their world around them and their parental figure in whatever form that might be. So I say that the Cliff Notes version is the following. Care is the provision of a safe, supportive, and nurturing environment that promotes a child's well-being, protects them from harm, and ensures that their best interests are prioritized. Next, I'll go on to the concept of contact, but before we go there, just to allay any concerns, I see Nadia has dealt with in the chat box. The slides will be shared, so don't worry about that, and we have one or two other resources that we also would like to spoil our attendees with, which will be shared at a later stage. So let's go on to contact. Now, contact I've split in two. If you really want to get a good feel for what contact entails, go look at the definitions and interpretations clauses of the Children's Act, and you will see this verbatim. Once again, not a very, very good definition to share with clients. However, we will be distilling it, but let's start over here. Now, I've put in at the bottom, contact is not just visits, ladies and gentlemen. Be careful when you draft settlement agreements, when you draft summonses, when you are busy negotiating contact with an opponent in terms of a matter. Contact is more than just visits. It's not every second weekend. It's not half of every long holiday or every short holiday. Do forgive me, my spaniel is crying outside my window. I'm not going to go open for her now. So if you do hear a yelp in the background, it's simply my dog wanting some attention. So please do forgive me for that. Right, so contact in relation to a child means sub A of the definition, maintaining a personal relationship with a child. And then B, if the child lives with someone else, it's communication on a regular basis with the child in person, including visits and being visited, or 2, communication on a regular basis with a child in any other manner, including through the post or by telephone or any other form of electronic communication. Now, I've labeled these to sub A, I've called the what. What do you want to achieve? You want to maintain a personal relationship with the child. What is the how to this what? It's subsection B, communication on a regular basis, in person, being visits and being visited, and communication in any other manner, including through the post, telephone, etc. I always giggle at through the post, but I won't belabor that point. So the focus, ladies and gentlemen, is not necessarily, when it comes to contact, on the sub B. The sub A comes before sub B. What is the focus? The focus is maintaining a personal relationship with a child. That is what this definition prioritizes, not so much the what, being the visitation, being visited, etc. I see Nadia has her hand up. You can unmute.
I'm so sorry to bother you. I just see there's quite a few people.
I can't hear you. I don't know if there's something wrong on my side.
Can you hear me? Maybe as a
Still can't hear you. I don't know what's happening. Do you want to send me a WhatsApp? I'll have a look at my WhatsApp and then just deal with it from there. So right, that is contact. Now, from this, folks, we can see that contact is a lot more than just the what. It is, or the how. It is the what followed by the how. So let's see, am I in trouble? Okay, a lot of people are struggling to connect. Okay, that's fine. Those who are struggling to connect, don't panic. We are recording. Nadia, if you can just pop out a message on the WhatsApp group and say to the guys who can't connect, don't panic. You will get it. Yeah, let's go on from there. Awesome. Okay, the thumbs up button still works. That's the one that matters. Right. So based on what we've gone through now, folks, with the sub A being the what and the sub B being the how, you can understand why I say contact is not just visits. It's not every second weekend. It's not just birthdays and public holidays, etc., etc. It is much more than that. There is an underlying intent here by the legislator, which we must bear in mind in dealing with contact. It is with regards to maintaining a personal relationship with a child. Why? Because unless there are compelling reasons why that's not the case, it is in the child's best interest to maintain a personal relationship with a child. I'm sure I'm preaching a bit more to the attorneys now than to the mental health guys who are very much more focused on this idea of relationships, but also understand those of us who are not mental health practitioners, that we must look further than the how and focus on the what. It's not sufficient to put in an every second weekend provision when there is pathos or pathology in the family dynamic. That needs to also be addressed under the heading of contact. Right, so here is the top one. I distilled it down a bit. The bottom one, I used a handy dandy AI compiler paraphraser on Microsoft Word to bring it down even more. I hope that these are of use to you. Once again, not legally accepted definitions. They are simply a summary to aid understanding. And I say the following: contact with a child refers to maintaining a personal relationship with them through regular communication, whether in person or through other means such as post, telephone, or electronic communication if the child lives with someone else. I distilled it down, I drilled it down another level. Contact with a child means keeping in touch with them on a regular basis, either in person or through other means like the mail, phone, internet, if the child lives with someone else. I like this last one. I don't think it encapsulates everything perfectly, but it makes it a hell of a lot easier to understand if you're not reading it in legalese. So now we've gone through care and we've gone through contact. Now let's get to this darn kettle of fish, and this is guardianship. Let's look at the concept of guardianship. Now, folks, you won't find a definition of guardianship in the definitions clause of the Children's Act. You'll find it under section 18(3) of the Children's Act. For some reason, they put those powers in there. A person who acts as a guardian must, not may, it is a must, it is peremptory, not permissive, administer and safeguard the child's property and property interests, assist or represent the child in administrative, contractual, and other legal matters, or give or refuse any consent required by law in respect of child's marriage, adoption, departure or removal from the Republic, application for a passport, or the alienation or encumbrance of any immovable property of the child. And now you'll see subsection C are a whole bunch of concepts lumped together, and I'll explain to you a bit later why that is. I decided to also put in a dictionary definition over here, simply because I think it is a nice aid to understanding. And the dictionary definition that we've got over here is the position of being legally responsible for someone who is unable to manage their own affairs. I quite like that definition to an extent. I like the term legally responsible. I think it does overlap quite nicely. Please, once again, that is not a legal definition. It is a dictionary definition. So don't dispense it as if it were advice. So how do we distill down the idea of being a guardian? And this is the crack that I took at it. Drilled it down one level, and I then drilled it down another level. Guardianship involves the responsibility of a parent or other appointed person to safeguard a child's property interests, assist or represent them in legal matters, and give or refuse the consent required by law in terms of marriage, adoption, passport applications, and alienation or encumbrance of immovable property. I couldn't drill it down too much more because it's quite specifically stated in the Act, but I did take a crack at it, and it's throughout the following. Guardianship means that a parent or other duly appointed person is responsible for protecting a child's property rights, helping or representing them in legal matters, and giving or refusing legal consent for things like marriage, adoption, passport applications, and the sale or transfer of immovable property. Once again, now it is something that is a little bit more palatable and a bit easier to digest than simply referring to the legalese in the Children's Act. Now, guardianship is a very, very profound parental responsibility and right. And as I'll show you folks later, when we talk about our 18(3)(c responsibilities and rights, always, if you hear 18(3)(c, always be very, very vigilant. These specific ones, which I'm going to do with a highlighter over here, those guys there, you require the consent of both co-holders of parental responsibilities and rights before any action that is consented to by either of the parties in respect of the child will be of any force or legal effect. So, for example, both holders, in the case of parents, must consent to the child's marriage and to the adoption and or the departure and or application for a passport and or alienation or encumbrance of immovable property of the child. Now, marriage is something we do not see very frequently in South Africa. It does pop up from once in a while, but generally we don't see as much consenting to the marriage of children in a standard civil legal practice, but it does come up from time to time. Child's adoption, I'm sure our NGO guys deal with that quite a bit, but once again, in a normal civil practice law firm, you don't really see that much of that. And then sub 5, the consent to the alienation or encumbrance of immovable property, unless your client's surname is a very, very prominent, very wealthy family, you're not really going to deal with that as much. But 3 and 4 are where a lot of skirmishes are fought. Departure or removal from the Republic, especially now, with a lot of people jumping ship to seek greener pastures in other countries. We do sit with a lot of issues regarding departure or removal from the Republic. And then the upshot from there is the application for a passport. Be aware of these. Then let's go on to maintenance. Now, folks, ironically, maintenance is a bit of a problematic one because we don't have a definition in either the Children's Act or the Maintenance Act even of maintenance. So I've had to go digging a little bit deeper, and thank goodness the Department of Justice website gave me a little bit of something to work with to share with all of you, and it is this. Maintenance is the obligation to provide another person, for example, a minor, with housing, food, clothing, education, and medical care, or with the means that are necessary for providing the person with these essentials. This legal duty to maintain is called the duty to maintain or the duty to support. Once again, folks, not a legal definition, even if it is from the Department of Justice's website. We need to take it with a pinch of salt because it is not based in legislation or in case law. I have, however, still tried to distill it down, and I got this very simple sentence. Once again, not legally accepted definition, purely a summary to aid understanding. Maintenance is the legal obligation to provide a minor or someone else with the necessary support, such as food, shelter, education, medical care, or financial means, also known as the duty to support or maintain. Nice little tidbit to share with clients. Very, very simple. Right. Now, folks, we have now defined the 4 wheels of our car. As I said earlier, parental responsibilities and rights is a group of responsibilities and rights that a person may have in whole or in part in respect of a minor child, and the Children's Act then defines these as contact, care, guardianship, and maintenance. Now, we've had a look at contact or care first. It's the provision of a safe, supportive, and nurturing environment that promotes a child's well-being, protects them from harm, and ensures their best interests are prioritized. We've looked at contact, which means keeping in touch with a child on a regular basis, either in person or through other means, if they live with someone else. We've looked at guardianship, which means that you have a responsibility to protect the child's property rights, helping and representing them in legal matters, giving or refusing various legal consents. And then finally, maintenance, which is the legal obligation to provide someone with necessary support such as food, shelter, education, medical care, or financial means, which is also known as the duty to support or maintain. Now, who has parental responsibilities and rights? I've distilled this down. There are nuances and caveats to all of these things, but I think in terms of today's webinar, I'm not going to delve too much into these things. I'm simply going to say, here are 6 circumstances. Mothers in terms of section 19, married fathers in terms of section 20, unmarried fathers subject to certain conditions in section 21, people under parental responsibilities and rights agreement under section 22, court orders, you can apply to court for these rights to be bestowed, section 23 for contact and care, and section 24 for guardianship, and then section 27 for guardianship and care under a will. Now, obviously, we don't deal in here with surrogacy agreements, which is something different. But these are the 6 most common scenarios where someone will be vested with parental responsibilities and rights. Okay. That being said, let me have a sip of water. Then we're going to go into how are parental responsibilities and rights exercised, which I think becomes a little bit more meaty based on the very, very foundational discussion we've had to date. So what we must understand about parental responsibilities and rights and their exercise is that there are various categories of exercising parental responsibilities and rights insofar as decision making is concerned, and we'll go through them. I'd like to start off at the standard and the default position, which really is a hard pill to swallow for a lot of people. However, this is what the Act says, so this is the law. When more than one person holds the same parental responsibilities and rights in respect of the child, each of the co-holders may act without the other co-holder's consent when exercising those responsibilities and rights. I'll read that again without tripping over my tongue. When more than one person holds the same parental responsibilities and rights in respect of a child, each of the co-holders may act without the consent of the other co-holder or holders when exercising those responsibilities and rights, except, and I've put this in red, this Act or any other law or order of court provides otherwise. That is Section 32 of the Children's Act. So, folks, from the outset, the Children's Act does not intend for co-holders of parental responsibilities and rights to micromanage one another. It is not the intent of the legislator. There is an intent that there be co-parenting, and we'll look at that a little bit later, but there is not a provision that says you have to clear every single decision that you want to make in terms of exercising your parental responsibilities and rights with the other co-holder. In fact, the default position in our law, if we start at Section 30 as our outset, is that you can act independently of the other co-holder of parental responsibilities and rights. Now, when we look at Section 30, we must always qualify it by certain other sections. And I'm going to jump actually ahead. I'm going to start with Section 18 before I go into Section 31. Section 18.5 of the Children's Act, ladies and gentlemen, says that unless a competent court orders otherwise, the consent of all persons that have guardianship of a child is necessary in respect of matters set out in subsection 3C. Now, what are those aspects? I mentioned them to you earlier, but I will repeat them. It's marriage, adoption, departure or removal from the Republic, application for a passport, or consent to the alienation or encumbrance of any immovable property of the child. So in these cases, you'd need positive consent from both parties. And those of you who, like me, deal with quite a lot of expat matters will know there are safeguards in place. Home Affairs, for example, is very, very reticent, to say the least, to process a passport application with both parents being physically there at their offices. The customs officials at OR Tambo, etc., are trained to look for the marriage certificate to see whether this child is traveling with both parents or not. And if not, they look for the Home Affairs consent affidavit, which must be not less than, if memory serves, 3 months old at the time of departure from the Republic. So in these cases, our 18.3c cases, you need positive consent from both the parents, if it is in terms of two parents holding parental responsibilities and rights, or from all holders of guardianship in terms of the child. If you cannot get it from that person, you can approach the court. And it's phrased funnily. It's not saying get consent, otherwise you can approach the court. It says unless a competent court orders otherwise, which clearly means that you can approach the court. And we know that there is quite a myriad of case law of people having approached the court on these types of matters to dispense with the consent of their co-guardian for the child to travel abroad or depart from the Republic at least. Okay, so let's just backtrack a bit. Default position, section 30, you can act independently. Unless it's a section 18(3)(c) matter, then you need positive consent or a court order. Then we have two different subsets which are very often confused, and I'm going to split them today just to assist in understanding. The first subset is section 31(1), major decisions, and the second subset is section 31(2), major decisions. And these two subsections deal in turn, the first one, section 31(1), with children, and section 31(2) with co-holders. Now, let's just demystify one or two issues in terms of section 31(1) and 2. A lot of practitioners act as if section 31(1) and 2 imply that you need consent. You do not need consent. You simply need to take into consideration, give due consideration, I'm going to highlight there with a laser pointer, any views and wishes expressed. You don't have to agree with them, you don't have to follow them, but you must, in a rational way, take them into consideration. Now, let's understand the purpose of section 31. In terms of section 31(1), it is to give the child the opportunity to participate in major decisions that affect their life. That goes back to our section 10, child participation, etc., etc. The child has the right, in terms of the Children's Act, to, in an age-appropriate way, obviously, participate in these major life-changing decisions. Then section 31(2), the underlying intent of the legislature, sorry, mixing the two words for a very, very poor portmanteau. The intention of the legislature in promulgating section 31(2) is very simple. The intent of the legislature there was to promote co-parenting. You cannot be judge, jury, and executioner as a co-parent, even though you have this section 30 right to act independently. So on that backdrop, let's quickly just disseminate section 31 and section 31(1) and section 31(2). Before a person holding PR&R in respect of a child takes any decision contemplated in paragraph B involving the child, that person must give due consideration to any views and wishes expressed by the child, bearing in mind their age, maturity, and stage of development. And then it lists 4 factors. Matter in connection with section 18(3)(c). So we spoke earlier, just as a refresher, 18(3)(c) is marriage, adoption, departure or removal from the Republic, application for a passport or consent to alienation or encumbrance of immovable property. Then, any matter or any decision affecting contact between the child and a co-holder of PR&R. 3, regarding the assignment of guardianship or care in respect of the child to another person in terms of section 27. Those of you who are quite sharp will remember section 27 is when you assign guardianship or care under a will. So in other words, if you or a client of yours is planning to do a will, number 1, advise them in terms of section 27, they need to choose a guardian and someone who will have care over their child. And number 2, more importantly, don't just do it. Talk to the child. Find out what the child wants and do it in an age-appropriate way. Please don't ask a 4-year-old, what do you want to do when mommy and daddy pass away? It will be something that does not end very well. Please do it age-appropriately. And then finally, sub 4, any matter which is likely to significantly change or to have an adverse effect on the child's living conditions, education, health, personal relations with a parent or family member, or generally the child's well-being. Now, on any of these 4 issues, you need to take into account and give due consideration to any views and wishes expressed by the child, bearing in mind their age, maturity, and stage of development. Now, folks, there is a beautiful saying which does the rounds, which I think is a controversial saying for the reason that it promotes absolutes. The saying is that the child has a voice but not a choice. Well, that's true, but if the child's voice is vocalizing something rational, something reasonable, if they are able to express themselves in a coherent and a compelling way, should we not listen to them? I want to leave that question with you because there seem to be two camps, and I don't want to go into preaching this. The one camp says the child can have what they want. The other camp says, well, wat weet die kind? The child has a voice but not a choice. Section 31.1 makes it incumbent on practitioners who deal with family matters, not just lawyers, advocates, or social workers, psychologists, etc., but mediators as well in a very, very big way. In these major decisions, let's give due consideration to the views and the wishes expressed by a child, bearing in mind their age, maturity, and stage of development. Let's draw this down to parenting plans, folks. A parenting plan definitely affects contact between the child and a co-holder of PR&R because it's defined in the parenting plan. Very often your parenting plans will have Section 27 provisions in them. They definitely significantly change the child's living conditions, education, health, etc., etc. So when it comes to not only major decisions on a day-to-day basis, but also when formulating things like settlement agreements, parenting plans, consider whether these provisions in those documents don't constitute major decisions envisaged in Section 31 and give due consideration, not just lip service, due consideration to the views. That is what the legislation requires. If the child has a very, very strong view and it's a well-founded, rational view and they can express that view, I would very, very strongly propose that we have a duty as legal practitioners, mental health practitioners, and as parents to listen to those views and wishes. Right. Now let's go into major decisions and co-holders of parental responsibilities and rights. The Act reads as follows: before a person holding parental responsibilities and rights in respect of a child takes any decision contemplated in paragraph B, that's paragraph B of subsection 2, that person must give due consideration to any views and wishes expressed by any co-holder of PR&R in respect of the child. Now, sub A of subsection 2 reads very similar to sub A of subsection 1. Simply says, give due consideration to the views and wishes expressed. Okay, fair enough. So far, so good. Only difference is the one section deals with the child, the other one deals with the co-holder. When we get to B of the subsection, that is where the devil lies, because when we talk about subsection B in respect of a child, there are 4 different factors. Section 18.3c, something affecting contact, something regarding the assignment of guardianship, etc., or something which is likely to have a significant change on the child's day-to-day life, as it were. However, when we go to B of subsection 2, there's only one factor, and it's a decision which is likely to change significantly or to have a significant adverse effect on the co-holder's exercise of parental responsibilities and rights in respect of the child. So you do not necessarily, for day-to-day decisions which do not have a significantly adverse effect on the co-holder's exercise, need to discuss or hear their views. Now, just because you can doesn't mean you shouldn't, and it also doesn't mean you should capriciously do these things. So, for example, one of the contentious issues between parents is moving schools. My child is in Hoërskool Noordheuwel. I want to move them to Monument or to Florida. Well, it doesn't change my co-holder of parental responsibilities and rights exercise of those parental responsibilities and rights. But is it in the best interest of the child? Don't forget section 7 when we talk about these different things. And for those who are going to stick around, I do encourage you to stick around. I've done a decision tree on this, which I'm going to walk you through, and we're going to do a few practical scenarios on it. Let's talk about moving a child from a very upmarket private school to a government school. Is that necessarily in the child's best interest? Is it a rational decision? Is it not something that one must discuss with a co-holder and with the child, etc.? So if one considers the exercise of parental responsibilities and rights, you need quite a bit of common sense, if I can put it that way, in dealing with these issues. Section 30 says, well, you can act independently. Section 18 says, right here, in terms of these things, you need both parties. So those two are very kind of simple. In terms of our Section 31 issues, though, we sit with gray areas and we sit with interpretation issues. What is a significant adverse effect versus an insignificant adverse effect? And it comes down to the fact that one cannot act capriciously or with malice in these types of matters. Take into account the people around you who are going to be affected by your decisions, whether it's the child, whether it's your co-holder, etc., etc. So what I've done to solidify this, I'm going to just nominally, there's just a closing off slide. If anyone doesn't have my details, please do take note of it now. And I'm going to give you 5, 4, 3, 2, and 1, and I'm going to stop sharing this presentation. And I'm very quickly going to share something else with you, lest you be subjected to seeing my face on the big screen without any further distractions. I'm going to share with you a decision tree which I formulated based on this discussion of Section 18, Section 30, and Section 31. Nadia, can I just check? On the last slide, I look like I'm up to serious mischief. Thanks, Corin. I usually am. You know me well enough. Can you guys see my PDF that I'm sharing with you right now? Zoomed in hectically. Fantastic. Nadia says thumbs up. Corin says yes. So let's rock and roll. So I've done it in the form of a flow chart. Obviously, it is a guiding tool. I am going to be sharing it with you before people ask, but use it wisely, right? So let's start over here. There is a decision to be taken. Our non-raced, non-gendered little caricature person standing on a question mark stands there and says, okay, I need to take a decision. Let's start off where we should always start off. Best interests of the child standard. Now, all of us know Section 7 is where you're going to find the best interests of the child standard. Question 1, is this decision in the best interests of the child? Very simple. If it's no, stop. Don't take it any further. If the decision is not in the best interest of the child and you take the decision, you are already falling foul of the law. Number 1, you're falling foul of Section 7. Number 2, you're falling foul of your obligations as someone who has the parental responsibilities and right of care under subparagraph J, which says to ensure that the best interests of the minor child is paramount in all considerations. So if it's not in the best interest of the minor child, just stop. Don't go any further. Now, best interest of the child is often open to interpretation. If the issue, for example, of where should a child stay, mom thinks it's best interests with her, dad thinks it's with him. If those cases did not exist, our children's courts would be pretty empty. Now, we know that these things are open to interpretation, but if it is patently not in the best interest of the child, just stop. Don't go any further. don't even entertain the thought any longer. If you say yes, in my view it is, then we go to the second section of our decision tree. And let me just get scrolling nicely. There we go. And that takes us to section 18.3c, guardianship decision. Question 1. Is this a section 18.3c decision? And I've listed them there for you. Marriage, adoption, departure or removal from RSA, application for a passport, or immovable property. Okay, so let's say yes it is. Next question. Do you have consent from a holder of parental responsibilities and rights? If no, do you have a court order dispensing with their consent? If no, stop. You can't go any further than that. So let's now go back to this decision tree. Is it a section 18.3c? Yes, it is. Great. Do you have consent? Yes. Then there's another requirement. Have you considered the views and wishes expressed by the child? Remember, sub 1 of subsection B of section 31, it's a mouthful, but just remember the Children's Act says when you take a guardianship joint decision, you have to take into account the views and wishes of the child. Have you done so? Yes. Cool. Go ahead. If you have consent, you've cleared it with the child, yes, you can go ahead. If you have consent, you've not cleared it with the child, well, stop. Go and talk to the child first. Let's say, no, you don't have consent. Then you can say, okay, great. Let's get a court order dispensing with consent. Do you have that court order? Yes. Then you still need to consider the views and wishes expressed by the child. If yes, go ahead. That takes care of guardianship decisions, right? Now, very important on this decision tree, folks, please don't treat it in a linear way necessarily, because very often it's not going to follow this formula of do you have consent from a co-holder first and then consider the views and wishes. Very often, let's talk about immigration. The child will, when they catch wind of a potential immigration, very quickly say, yes, I'm for it, no, I'm against it. Then this 31 1B1 will fall somewhere in the top there before the consent of the other party, etc. Just use common sense. But understand, for guardianship decisions, whose consent do you need? Either the co-holder or the court. Whose views do you need to take into account? The children or the child. And that is your decision tree on guardianship decisions. Now, it might not necessarily be a guardianship decision. If it's not a guardianship decision, and we follow the no line, right here, down, 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 you can still fall into the realms of major decisions. Is this a major decision in terms of section 31.1? Now remember, what are 31.1 deals with? Child, not the co-holder. Is it a major decision in terms of section 31.1? Is it a section 18.3c, for example, which we've just dealt with? Does it affect contact with a co-holder? Does it deal with guardianship or care in a will? Does it lead to a significant change in living conditions, etc., etc.? If no, check whether it's a 31.2. If yes, let's finish this tree first. Have you considered the views and wishes of the child? If no, stop. If yes, then we go on to, is this a major decision in terms of section 31.2? Now, I want to pause here. I've put it in this way because this is how it's written in the legislation. Section 31.1 comes first, then section 31.2. Please don't go and tell your clients that Mervyn Vermeulen said you must first talk to the child and then make a decision and then talk to the co-holder. It doesn't necessarily happen that way. So it may be that in some instances it's more appropriate to first talk to a co-holder before talking to the child. Just ounce of common sense outweighs a ton of law. Just bear that in mind. But for purposes of this decision tree, we've gone 31-1 first. So let's say you've considered the views and wishes of the child. Great. Now you have to go on and say, is it a major decision in terms of section 31.2? Is it likely to change significantly or to have a significant adverse effect on the co-holder's exercise of parental responsibilities and rights? If yes, have you considered the views and wishes of that co-holder? If no, stop. If yes, go. If it is not a major decision in terms of section 31.2, go. So if I then zoom out, this is what your decision tree is going to look like. And I'm going to share this with you guys. It's easy to print on an A4. Let's run through it practically. It's now 11 o'clock. I'm going to take 10 minutes to run through this, and then we can go into Q&A. Okay, let's decide decision to be taken. Does anyone have a suggestion for a decision to be taken? Please pop them in the chat bar. I'm going to take the first one. I think a good example is adoption. Let's start with the issue of adoption first. I want to put my child up for adoption. Best interest of the child standard. Number one, is the decision in the best interest of the child? If no, stop. Okay, now let's go on to, yes, let's say mom is 18 years of age, doesn't have a job yet, still wants to study, incapable of looking after the child. Then the adoption might be in the best interest of the child. Then let's go on. Is it a guardianship decision? Yes, it is. It's a guardianship decision in terms of section 18.3c. There we see it right there, adoption. Do you have consent from a co-holder of parental responsibilities and rights? Well, in this case, ask yourself, is there a co-holder? Is it perhaps a section 21 father? Well, let's say yes, it is. Does the dad consider or does the dad consent? Yes, fine. Then have you considered the views and wishes expressed from the child or by the child? In this case, it won't really be as relevant because generally with these types of adoptions, we look at very, very young children. But then, yes, we can go on. Or if dad doesn't want to consent, do you have a court order dispensing with a consent? If no, stop. If yes, go on. So this was clearly a major decision in terms of section 18.3c. We don't need to take it any further than that. Let's take another decision, for example. I had a matter recently. Let's say a client wants to relocate from Port Elizabeth to Polokwane. Very, very far apart. Everyone was staying in Port Elizabeth, and now let's say mom wants to relocate with a child to Polokwane. Great. Let's see. Is this in the best interests of the child? If not, just stop. Don't relocate to the Ukraine at this stage with the child because clearly it's not in the best interest of the child. Now, whether it is in the best interest of the child to relocate to Polokwane from Port Elizabeth is a qualitative assessment based on Section 7 of the Children's Act. Let's accept that it is. Then we go on to the next section. Now, this is where it becomes very interesting. Now, understand, Section 18.3c, we require consent. Marriage, adoption, departure or removal from RSA, passport or immovable property. Relocation from Port Elizabeth to Polokwane is not in any of these categories. So, in essence, folks, you don't need, in terms of the Act, consent. However, just because it's not an 18.3c doesn't mean it is not a major decision. Now let's first talk about the child's position. Is it a major decision in terms of Section 3031(1)? Does it deal with anything under Section 18? No, it doesn't. Does it affect contact? Oh boy, yes, it does. Does it deal with guardianship or care in a will? No. Is it a significant change in living conditions, education, health, etc.? Yes, absolutely. So first off, before anything, we must understand that this is a Section 31(1) major decision. Have you considered the views and the wishes of the child? No. If not, stop. If yes, that's not the end of it. You have a co-holder. Is this a major decision in terms of Section 31(2)? Is it likely to change significantly or have a significant adverse effect on the co-holder's exercise of parental responsibilities and rights? Hell yeah, it will. Because you're moving the child cross-country, where dad could simply pick the child up from school every afternoon. Now, all of a sudden, the child is sitting in Polokwane and he can only see the child once or twice a year, flights permitting. So, have you considered their views? If not, stop, because your actions are illegal. You can be interdicted from doing the move. If you have considered their wishes, great, go on. Does this mean that the parent wanting to take the action has carte blanche? No. I would remind you of the decision of Uber versus Uber, if memory serves, which says that you don't need consent, but if the decision is not rational or if it's capriciously made, it can be reviewed by court. So, for example, you can still interdict on a balance of prejudice. I will be more prejudiced by this person moving than they will be by staying here. And then it's a qualitative assessment. So that is in the case of relocation. So we've had a very clear Section 18(1), and we've had a very clear Section 31. Let's deal with something a bit more controversial. Decision to be taken. Mom wants to move the child from Noordheuwel High School, which is in Krugersdorp, to Helpmekaar, which is near town. Is it in the best interest of the child? No, without school pride or blah, blah, blah arguments, let's just assume yes, it is. Okay, going from a semi-private public school to a private school. Great, there we go. Is it a guardianship decision? Well, it's not marriage, it's not adoption, it's not departure or removal from RSA, it's not a passport, it's not immovable property, so safe to say it's not an 18(3)(c). Let's go down, 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 down. Is it a major decision insofar as the child is concerned? Well, does it affect contact with the co-holder? I don't know. We'll have to look at that. Does it regard guardianship or care? Well, nope. Does it significantly change their living conditions, education? Right there it is. So yeah, absolutely. This is a major decision in terms of the child. Have you considered their views? If not, stop. If you've considered their views, let's go on over here. Is this a major decision in terms of Section 31(2)? Is it likely to significantly change or have an adverse effect on the co-holder's exercise of PRR? Now, this is where it becomes difficult, ladies and gentlemen, because there is no right or wrong answer. Let's talk about moving from Noordheuwel to Helpmekaar. Let's create a profile of two dads. Dad 1 is self-employed, has a lot of time on their hands. Dad 2 works for corporate with nary 2 seconds to rub together in a day. Dad 1 attends every single sporting event, fetches the child from school 3 times a week, and is very involved. Dad 2 sees the child on weekends exclusively. Is the change of school likely to significantly change or have a significant adverse effect on Dad 1's exercise of PRR? Absolutely, it will. It's going to stop him from fetching the child from school. It's going to make attending school functions more difficult. So it is a major decision. For Dad 2, who is a salary earner, who doesn't have 2 seconds in a week to go to a school event, qualitatively, Will it likely lead to a change or have an adverse effect on the exercise of PRR? I don't think so necessarily. The point that I'm trying to make in this regard, ladies and gentlemen, is that Section 31(1) and 2 is not always clear cut. You have to look at the circumstances. You have to go back to the Act and see how to transpose the facts of your matter onto the Act. Now, just because it is not necessarily a 31(2) significant change, it doesn't mean it's a legal decision. It doesn't mean it's the best decision. It doesn't mean you can't be interdicted. The High Court has inherent jurisdiction to hear these matters. The Children's Court has very broad powers to hear these matters. So if it is a decision which on balance might be prejudicial, you might pick up problems in court. So there are no clear rules applicable to these matters, save for Section 18, which is very clear, and the broad guidelines that we have in Section 31(1) and Section 31(2). I encourage you folks, because we are dealing with very, very interesting sections here, when it comes to co-parenting and making major decisions, I encourage you to use a tool like this decision tree, which obviously you're welcome to use mine or to create your own in your practice. Don't be bound by it. Don't see it as the be all and the end all, and you have to follow these lines. It's a piece of paper. We're people. We're dealing with unique circumstances. No piece of paper will ever encapsulate that. One of my favorite sayings, families are not formulaic. They're not. But use it as an aid to explain to your clients what they are intending to do or the objectives they intend to achieve fall in and how to best position themselves for it. So, folks, that really takes care of the formal portion of today's webinar. It's been really great sitting with you folks and talking through what I think is a very, very basic and foundational concept in the Children's Act, but one which is very, very often misunderstood and oversimplified or overcomplicated, as it were. And then hopefully our section on decision-making, major decisions and guardianship decisions was of benefit to you.